Participants to have a look at the guidelines that are on the cards on the table. These measures are in place to prevent audio incidents.
Mais c'est en français, là.
Poste français, est-ce que vous entendez?
Pour qu'on s'en prive dans une traduction.
Hein? Is the translation working?
Ouais, mais je pense que c'est mon appareil qui...
I think it's my earpiece.
We'll just take a pause and fix it.
Leur micro n'est pas allumé. Leur micro n'est pas allumé, donc j'imagine.
Avant de continuer,
So, before we continue, I would like to ask all participants in person to review the guidelines written on the cards on the table. These measures are in place to help prevent audio incidents and acoustic shocks, and to protect the health and safety of all participants, especially interpreters. You will also notice that there's a QR code on the card that links to a short awareness video if you want to watch it.
for the benefits of witnesses and members, please wait till I recognize you by name. Before speaking, for those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you're not speaking. And for those on Zoom, at the bottom of the screen, you can select the appropriate channel for interpretation, English or French or the floor language. For those in the room, you can use the earpiece, obviously, and select the language of your preference. Reminder again, and I think we've been doing this up to date, that all comments should be addressed through the chair. I thank you for that. Et pour tous les députés présents dans la salle, si vous...
And for members in the room, if you wish to speak, please raise your hand. For members on Zoom, use the raise hand function. But we're all here in person. The committee clerk to my left and I will do our best to maintain the order of speaking, and we thank you for your patience and understanding in this regard.
Present the three witnesses today, but I did want to address one issue since C9 has been referred to this committee. The minister is prepared to present and appear as early as next Thursday. Obviously, with legislation taking precedence, I assume it is the preference of this committee to move forward on that study, assuming I'm not teeing up or preparing anyone for a disappointment of him not being here, but assuming he is not available, I will also assume, unless someone objects, that we continue this study instead of doing something which is a little irregular and bringing in witnesses on C9 before the minister appears. But all signs seem to indicate from the Liberals and from our side that the minister will indeed be here on Thursday. Mr. Brock.
We do understand in principle that government bills take precedence at all committees. It's a long-standing tradition. I understand that. But I think we can accomplish two matters at the same time, in my view. And it would be, I believe, the Conservative team's preference. I haven't spoken to my bloc colleague yet, but to run concurrent studies so that the week is divided between the bail and sentencing study that we just nicely got started and devote a significant amount of time to Bill C9. I don't see any reason why we can't run both at the same time. We could look at one day of the week for C9 and one day of the week for our current study that we started last Thursday. So that would be our collective preference. I don't know what the thoughts are of Monsieur Fortin, but I'd hate to stop the momentum, and given that this is such a pressing and growing concern in Canada, I don't want this to resume sometime in December or even after the Christmas break.
Do people want to?
Knowing that if the Liberal government promises come to fruition, that we heard today in the House repeatedly, that within a few weeks that we are expecting to see a bail and crime bill that ultimately is going to land here at Justice as well. So I think that we really need to put enough resources into both studies, as both studies warrant our immediate attention.
Do we want to talk this out now? I know we do have a full slate of witnesses today. We can table this discussion till Tuesday if that's better.
Fine.
I think we do have some more time on Tuesday, but let's think this through, and perhaps if people want to speak with Monsieur Fortin and see where the thinking is at there. But these are both priority items, so let's table that discussion till Tuesday. So for today's panel, we do have with us three people. First, from the Association des Avocats Noirs du Canada.
First, from Canadian Association of Black Lawyers, Teresa Donker, Director of Advocacy. Canadian Association of Elizabeth Fry Societies, Nikki Kish, Co-Executive Director. And from the Canadian Bar Association, we have Melanie Webb, Chair of the Criminal Justice Section. Welcome, all three.
Remind the witnesses that they have 5 minutes for their opening statements. I'll allow some flex at the end as it's going on, followed by questions from the members of the committee in the orders that we've predetermined in previous meetings. So without further ado, the floor is yours. Teresa, the floor is yours for opening speech.
Thank you. Good afternoon. Thank you to the chair and committee members for inviting me to speak on behalf of the Canadian Association of Black Lawyers. We at CABLE share the government's desire to make our communities safer, especially Black, Indigenous, and marginalized communities that disproportionately bear the weight of crime, policing, and punishment. But enacting legislation that lacks evidentiary support will not make our communities safer. While we've seen police agencies and other stakeholders urge for stricter bail and sentencing laws, we have yet to see empirical evidence that those stricter laws will achieve the public safety goals that they aim to address. What empirical evidence we do have paints a different picture, and I want to share 4 examples with you. First, a couple of weeks ago on September 11th, the Toronto Police announced that shootings and firearm discharges are down 40%, auto theft has decreased by 33%, break-and enters have decreased by 13%, and homicides have dropped 51% from this time last year. That is incongruent with the rhetoric that our communities are becoming more violent and less safe. Second, In 2024, the Canadian Civil Liberties Association, in its report on pretrial detention, found that almost 80% of people in our provincial and territorial jails are legally innocent, awaiting bail or trial. That number has more than doubled over the last 40 years. That is certainly not indicative of a catch and release system. Third, Statistics Canada reported that there were over 200,000 adult criminal court cases in 2022 to 2023. Less than half of those cases resulted in findings of guilt. This highlights why the Charter-protected right to a reasonable bail is so important. And fourth, a 2017 Statistics Canada report noted that there's no evidence that mandatory minimum penalties deter crime. Rather, some studies demonstrate that they lead to increased costs to the justice system and that lengthier sentences may actually increase recidivism. This shows that some of the proposed reforms, the ones that remove judicial discretion, may simply cost more money to taxpayers and yet will not make our communities safer. The reality is we do have issues with our criminal justice system, but they are not the same issues that are continually broadcasted by the media. Some of us witnesses here today have practiced or are currently practicing as criminal defense lawyers. What we see is increasing delays in having bails and trials heard in a reasonable time, a right that is enshrined in our charter. We see that our jails are overpopulated. We see dangerous and inhumane living conditions in these jails, which judges have described as disheartening, if not appalling, deeply concerning, punitive and cruel, wholly unacceptable, and consistently failing to meet minimum standards established by the United Nations. These are the same jails that house presumptively innocent people before they are found guilty of any offense. These are the issues that erode public confidence in the administration of justice. And these pressing issues won't be fixed by stricter bail laws or stiffer sentences. We recommend that the government invest in more data collection so that more effective evidence-based reforms are achievable. We recommend that the government appoint more judges to address concerning delays and provide more funding for legal aid to promote access to justice. We recommend that the government consider policies that make social services and mental health programs that address the root causes of crime more accessible. While we know that there are cases where individuals reoffend while on bail, as even the police associations acknowledged here last week, that occurs with only a small number of offenders. We should not be making sweeping reforms based on outliers, and we certainly should not be making reforms that will inevitably fail constitutional scrutiny. We need to be engaged in criminal justice policymaking that is rooted in research, consultation, and evidence. We are pleased that this committee has undertaken a study of bail, sentencing, and the handling of repeat offenders as a step forward in this approach. And on behalf of CABLE, I welcome any questions that this committee may have for us, and I thank you for your time.
Thank you, Ms. Donkor. Ms. Kish.
Thank you for inviting us. For we too share in our country's collective desire to increase community safety and agree that we need cross-sectoral collaboration to do so. It is visible to all of us who walk through any downtown core in Canada that we have serious social problems. And at the Canadian Association of Elizabeth Fry Societies, we think about public safety every day as we support women and gender diverse people at all stages of justice involvement, pre, during, and post-incarceration. We understand prisons, and so worry by how strongly current discourses are calling for us to use prisons as the tool to solve our social problems. Expanding upon the sentiments of previous police witnesses, we simply won't improve public safety and solve the problems at hand by only changing laws that rid of bail and increase sentence length. We will be back at the same table in 5 and 10 years, for we cannot change laws without duly addressing what those laws will do in society, which will be to send more people into expensive and dysfunctional prisons. Our system can't handle increased incarceration. Ours is already one of the costliest prison systems globally, where despite our federal system having one of the highest ratios of staff to incarcerated people, our institutions remain harmful, both for those who are kept in and for those who work in them. Prisons are costly, counterproductive, and are responsible for significant ongoing public dollars being paid in continual damages and for broad peripheral social and economic costs. We have acknowledged as a country that punishing people doesn't work since 1938 when the Archambault report was released, recognizing then that sending young people into prisons causes them to be more likely to be recruited into further criminal activity, and that rehabilitation and reintegration are what work. And today, some 87 years later, conditions in prison are as dangerous and unproductive as ever. And I don't say this to pit the experiences of the incarcerated against the needs of victim, but to underscore that this approach does not work for anyone. People are leaving prisons worse than when they arrived, and this must be part of our conversation, for it contributes to our ongoing problems. People return to the community with untreated and worsened addiction or addiction that they developed in prison, with chronic physical and mental health issues, and with no money. Each of these factors decreases a person's ability to become a contributing member of our community and costs Canadians. We know what works. It is community investment and vocational opportunity. These things can shrink our prison problems and population down so that we can meaningfully respond to those people who do pose real risk. But we are continually up against public calls that imagine that a responsible prison system is one that is soft on crime. I offer that there is wide stakeholder agreement here suggesting otherwise, that it is not a soft on crime approach to understand that what happens to people in prison has an impact on public safety, but that this is a responsible and smart approach. So unless we are prepared to incarcerate people forever and want to build endless specialized prisons, we need to implement solutions that go beyond incarceration, focusing on cross-sectoral and community-led solutions that work, such as Ontario's bail verification and supervision program, which operates at a fraction of the cost of incarceration. In the Peterborough region, for example, just $1,100 per person per year, as opposed to the almost $90,000 per person per year that it costs to provincially incarcerate them. This lowers public safety risk, provides individuals with support and supervision on bail, and keeps them out of prison. Right now, our prison system is overwhelmed. It cannot meaningfully respond to the very small number of people who do pose risk, because there are few off-ramps for people who do not need to be incarcerated, and because prisons are being tasked with responding to an influx of unmet community needs, such as our addiction and mental health crises. Certainly, if we weren't unproductively incarcerating so many who could be better served in treatment facilities, or who are incarcerated lengthily, where they could much sooner become contributing members of our community, for all of the Indigenous women who simply need support to heal from intergenerational trauma, then the professionals in our system would have much more capacity to meaningfully respond to those small numbers of people who we are trying to address here. We need a responsive system in both directions. One that can respond to risk, but one that also provides opportunities to let people move forward and to be well. And I know it seems intuitive that when we see violence from previously system-involved people, we would lock them up for longer. But to every call being made for failed three-strikes policies, for femicide to raise murder convictions to first degree, and for more reverse onus, we could discuss further how these policy responses will fail at solving the problems they seek to. I'll close with a question, and that is, how many people would not have committed new crimes post-incarceration had they not been swept up into a dysfunctional prison? I offer words which I'll never forget of a previous farm manager from a transformative justice agricultural initiative in British Columbia. He was a repeat offender who learned from childhood, as he told me, to be a better criminal in prison, and continued this for 20 years, until he was given one good opportunity, and that was a chance to farm. He learned to grow food and then grew food for and with victims of crime, and said to me, "Nikki, I would never hurt this community. I would never harm a community that I'm part of, and I've never been part of a real community before." Thank you for your comments.
Thank you, Ms. Kish. Over to you, Ms. Webb. The floor is yours.
Thank you. Good afternoon. Thank you for the invitation to speak to you today in your study of these important justice issues. The Canadian Bar Association represents over 40,000 lawyers, students, academics, and jurists across Canada. Our mandate includes seeking improvement in the law and the administration of justice. The criminal justice section is made up of a balance of Crown and Defence Counsel from every part of the country. Many of our members also represent and provide advice to complainants during the course of criminal prosecutions. I am the chair of the CBA Criminal Justice Section and a criminal trial and appellate lawyer. The CBA appreciates that bail reform and addressing individuals charged with and convicted of violent offenses are top priorities for lawmakers. We share your commitment to public safety and acknowledge the importance of maintaining public confidence in the administration of justice. As we have stated before to this committee, any changes contemplated to the bail provisions must be evidence-based, consistent with constitutionally protected rights, and consistent with the long-standing principles of bail set out in the existing jurisprudence. Some have suggested that the rights of the accused are weighed more heavily than the rights of the complainant. The CBA is of the view that the bail provisions in the Criminal Code, when applied correctly, appropriately balance the concerns for public safety and the need to maintain confidence in the administration of justice with an accused's constitutionally protected rights, including the right to be presumed innocent until proven guilty. We suggest, however, that there is room for improvement in making our bail system more efficient. This would help focus more attention and resources on the most serious of offenses, including crimes of violence. Further, a large proportion of court dockets is taken up with accused persons charged with committing low-level, non-violent offenses who are often motivated by mental health or substance use issues. These persons are not receiving adequate supports to address these issues, even after being released on bail. An inefficient and overburdened system means that accused wait longer for their matters to be addressed in bail court. Pretrial detention centers become overcrowded, with people awaiting both bail hearings and their trials. Detained accused will be more likely to be given enhanced credit on sentencing for harsh pre-sentence conditions if convicted of a crime. Overcrowding also leads to physically dangerous and highly stressful conditions for both inmates and correctional officers. Overburdened dockets means that more cases, including those of persons charged with serious violent crimes, may be stayed as a result of court delays. As this committee has already heard, the provincial jails are no places for rehabilitation. Jails are criminogenic, meaning that incarceration without rehabilitation can actually increase the likelihood that someone may reoffend and be jailed again. In terms of inefficiencies in the bail system, some contested bail hearings take up more court time than a trial on the merits might take, and may not finish the same day. Courts in busy jurisdictions will not reach all matters that require a contested hearing. Matters are adjourned day after day. This leads to surety attrition, as well as negative collateral consequences for accused persons in custody, including loss of housing and employment. For longer matters, there can be many procedural requirements that must be met before the bail hearing can even be scheduled. We suggest that better case management and streamlining of bail processes generally would help prioritize high-risk matters over low-risk ones. Further research into tools to identify low versus high-risk cases would also be helpful. We suggest 2 amendments to the code to streamline bail hearings. First, we propose that it be clarified that all bail hearings can be conducted in a bifurcated manner that considers, first, the level of release appropriate, and second, the suitability of the proposed surety, if a surety release would be appropriate. Second, we propose that leave of the court be required for either party wishing to cross-examine a surety or a witness at a bail hearing. In most cases, counsel are well-equipped to provide meaningful submissions, and justices are well able to consider the relevant grounds without needing to actually call evidence as if a full-blown trial. I conclude with these final remarks. Persons who have been detained pending trial, who are ultimately acquitted, or have their charges withdrawn will never regain those years of lost liberty. That is precisely why every person charged with an offense has a constitutional right not to be denied reasonable bail without just cause, and why that right must be preserved. Thank you. I welcome any questions that the committee might have.
Thanks to all 3 of you. We have the first round, which, as members know, is 6 minutes each to the Conservative Party, the Liberal Party, and the Bloc Québécois, respectively. And then we start off with MP Gill, 6 minutes.
Thank you.
Thank you, Mr. Chair.
Thank you, Mr. Chair. I would like to start by thanking the witnesses for taking the time today. For the last decade, government policies have clearly failed to address the exponential rise in crime. While it is essential that we guarantee judicial right to the accused, we also have a duty to protect law-abiding citizens from repeat offenders. Statistics are clear. Most serious crimes are committed by individuals with prior records. According to Public Safety Canada, between 2019 and 2022, 53% of individuals charged with homicide were on bail at the time of offense. Given these alarming figures, what changes would you propose to ensure that individuals with a history of serious or violent offenses are not released only to reoffend? And how do we better balance the right of the accused with the right of the public to be protected from repeat violence? My question is to all of you.
I'm happy to start, but I will leave time for my colleagues to respond as well. I certainly appreciate the concerns about repeat offenders, as I believe we all in this room do appreciate those concerns as well. I would start off by saying that I'm not sure that the empirical evidence supports the notion that there's a dramatic increase in crime. But I do see that there is a concern about repeat offenders. And one thing that I would emphasize when we're talking about repeat offenders is what my colleague Ms. Webb emphasized, that prisons and jails have a criminogenic effect. I listened to this committee's meeting last week with the police, and I know that a lot of members, committee members, have expressed that they have done ride-alongs with the police. I would encourage you all to do visits to our provincial jails as well and our prisons. You will see the inhumane and dangerous conditions in those institutions, and you will see how those conditions have a criminogenic effect. If we truly care about keeping our community safer, we need to be concerned just as much with rehabilitation as we are with punishment. Because the reality is, if somebody is spending years in a cage without any programming, without any supports, without any rehabilitation, they will come out more dangerous. So if we really want to address these repeat offenders, we need to be hitting the root of rehabilitation and investing in rehabilitation to make our community safer.
Yeah, I'll just underscore what my colleague shared, and that's it's not a coincidence that so many people causing harm have been system involved previously, because the system is a contributing factor in the behavior post-release.
Thank you. I echo the comments of Ms. Donkor and Ms. Kish. And I noticed in her remarks that Ms. Donkor highlighted that Toronto Police Chief Myron Demkiw had reported that, in fact, there had been significant decreases in the numbers and rates of several serious offenses, including homicides, shootings, discharges of firearms, and robberies. I also took the opportunity to take a look at the stats for the region of Peel, and I also found complementary decreases in homicide, robberies, break-and enters, and auto thefts. So respectfully, my suggestion is I echo the entreaty of Ms. Donkor that we really need to focus on rehabilitation. But as we all know, and as I believe the president of the Canadian Police Association had testified to last week, unfortunately, our provincial jails are no place for rehabilitation. And that is what we really need to focus on. Thank you.
Well, my another question to you, and I heard that you understand the prisons and the prisoners, but I would like to know from each of you that how many victims did you consult for your testimony here today?
Well, thank you for that. I mean, I can indicate that I have personally represented victims of crime. I have had people who are close to me who are victims of crime. I have tried not to be insular. I can tell you that the Canadian Bar Association criminal section is a balanced section, which includes the input of Crowns who regularly interact with victims of crime, with complainants, and it's with all of that background and experience that I'm here today.
And I echo Ms. Webb's comments. I am a criminal defense lawyer, but I also represent complainants in sexual assault proceedings. So I've certainly heard their perspective, and I am here today not only speaking as a defense lawyer, but I'm also speaking as a Black woman. I'm also speaking as a woman who has represented other women and other victims of crime as well. So I do hope that in my sentiment, you are hearing a holistic perspective, and know that I'm speaking from a holistic perspective, not just from the perspective of the accused.
Similarly, our network always takes the opportunity to remind the public that many people who experience incarceration are themselves individuals who have been victimized by crime in their lifetimes.
Thank you, Mr. Chair. Thank you to all three of you for joining us today on this important study. I will direct my questions to you, Ms. Webb. The CPA has noted that bail laws are only as strong as the resources behind them. So what are the most critical gaps that you would see today in staffing, training, or infrastructure?
Well, I can only speak really sort of from personal observation on that specific issue. I can indicate that in the urban centers, like for example, the city of Toronto, the streets. It's evident, in terms of walking the streets or taking a ride on the TTC, that there are numerous persons who are mentally disordered, persons with substance use issues, who are inevitably caught. Some of them end up essentially being arrested, rearrested, released, and not receiving the community supports that they need. Now, in Toronto, we do have the bail supervision program. We do have resources like the John Howard Society, the Elizabeth Fry Society, and we do have people who unfortunately need a little bit more than that, or maybe significantly more than that. But the reality is that for people who are seeking adequate mental health services, they are often facing wait times of months, sometimes several months, before they can get the care that they need. And inevitably, that's frankly just not enough time for someone to get the treatment that they need before they might be reoffending and then essentially caught up in this cycle over and over again. So we are very much in support of investment in health and social services at all levels of government, and that requires proportionate investment from the provinces as well.
Have their Jail Not Bail Act to replace the principle of restraint in Section 493.1 of the Act with the principle of protecting and the protection of the public. So if the principle of restraint was removed from the criminal code, could it still exist in common law and be argued at bail hearings?
Thank you. Well, the principle of restraint, that is a long-standing principle that is well established in the case law. Bill C-75 simply codified it, and that was well set out by the Supreme Court in the Antic decision. I'm sure many people in this room are familiar with that decision. I frankly, in the limited time that I have today, would not be able to adequately describe and explain why that principle of restraint is so important, but I would urge everyone to take a close read of the Antic decision, which would explain why the principle of restraint is so important.
Opinion, is the protection and safety of the public a criteria already considered in bail hearings?
It is. And again, despite the fact that we return here, I think, every couple of years, and we talk about potentially considering adding more language to the code or adding more things or factors that a justice should consider on a bail hearing. The reality is that we have experienced judicial officers across Canada who, regardless of whether it's written in the code or not, are already taking these important factors into consideration.
And finally, the Conservatives, including the members on this committee, have already suggested to fix the bail system, suggesting that would require the use of the notwithstanding clause. Would you agree with that?
We would not agree with the use of the notwithstanding clause for reasons that are, I think, well set out in submissions that the CBA has made elsewhere. Frankly, we would focus on, again, trying to make our bail system more efficient so that we can focus on the offenses and the crimes that are of serious concern to the public.
Thank you, Mr. Chair. Since I have more time, I will address my question to Ms. Teresa Duncor. You've spoken about the importance of fairness alongside public safety. From your perspective, what safeguards are most important to assure bail laws are applied consistently and credibly in all communities?
Well, that's an excellent question. And I think that we need, for one, we do need more resources in our courts. We need more resources, more appointment of judges so that we're not experiencing the delays that we're currently seeing, especially in Ontario. But I also think that what's more important or as equally important is more funding, especially for legal aid, because I think we see disproportionately that individuals with more resources, more access to sureties, more financial resources are the ones that are able to be released on bail, as opposed to those from marginalized communities who may not have the same resources and access to sureties. And that doesn't necessarily mean that they're any more dangerous or they're any more of a risk to public safety. They simply do not have the resources. And that certainly is an equity issue that needs to be addressed.
I'm done. Okay, thank you.
Merci, Monsieur le Président.
Thank you, Chair. Ms. Webb, Ms. Duncor, Ms. Kish, thank you for being with us today. It is an important study. And you are saying that you followed the working of the committee last week, and you know that we heard from police officers and associations, and they came up with very sensible recommendations, but it's also important to see the other side of the coin. So I'm listening to your remarks, and I appreciate your participation. Now, as it's often the case in this kind of a study, the issue that is the most important is how do we triage all of this? How do you navigate between the presumption of innocence and the rights of the accused in a trial versus public safety? Of course, the principle dictates that people should be liberated at the first opportunity unless they do not meet certain criteria, if they're dangerous for themselves or for the society or if they cannot appear before court. Now, these are principles that I think should appeal to a large majority of people. But the problem is, how do we sort through all of this? Because we see repeat offenders who are released and who commit the same crimes. There is one in my riding, for instance, this week. There was an incident, and apparently it's been 16 times that he did not respect the conditions of his release and ended up killing his spouse. So it's unacceptable. Now, the Canadian Bar Association first, maybe, Ms. Webb, at the moment, some aspects are not well defined. There is no consensus. But would you have any particular recommendations to us quickly, if possible? But how can we make sure that these principles are respected so that violent people are kept in prisons rather than being set free?
Thank you. Well, first of all, we need to start with the presumption that regardless of someone's criminal record or the number of outstanding charges that they have, and regardless of their background, that they are still legally presumed innocent until proven guilty. I think that we all understand and accept that. Notwithstanding that, we also must balance the protection of the safety of the public, including any complainant or witness. That is written right into the secondary ground in terms of the grounds that a justice must consider. So there's nothing new there. I mean, I can indicate that in terms of, we're talking about intimate partner violence. I think no one would disagree that intimate partner violence is a scourge upon society. Sadly, I think we need to do better to address what is causing intimate partner violence.
Mais how to do better? This is the question.
Yes.
Comme je le disais, là, est-ce que
As I was saying, well, I mean, is there a definition of criminal repeat offenders, multiple repeat offenders? As far as I can tell, there is no clear definition. Would it be important to come up with a definition, or are there other solutions? And I apologize because my time is very limited.
I mean, I can tell you that certainly there are repeat offenders who come before the court, but I think that we need to be careful about unfortunate, tragic outlier cases in which, unfortunately, a fatality may occur, a homicide may occur. And unfortunately, our society is never going to be 100% secure against the dangers of that happening. All we can do is properly apply the law as it is set out, and there will absolutely be people who are unfortunately too much of a risk to be released.
Merci, Madame Webb. Je m'excuse, mais il doit rester à peu près une minute.
Thank you, Ms. Webb. I think I have only a minute left. Ms. Donker on the same question, and thank you, Ms. Webb. Ms. Donker, if you want to go ahead and answer the same question, what needs to be done so that the violent and dangerous accused remain behind bars, and in addition to being able to stick to the principle of the presumption of innocence? How do you sort through all of this?
Well, in my opinion, the criminal code does already account for this. As Ms. Webb noted, we consider public safety in the secondary ground. And I do want to make clear, because I've heard some discussion around this, and I think it's important to not lose sight of the fact that the principle of restraint doesn't require that those charged with violent offenses be released. That's simply not what the principle of restraint is. And the principle of restraint does not override the test for bail. So the principle of restraint makes clear that a person should be released at the earliest instance possible, and the least restrictive terms where appropriate. So we're still going through the test for bail. We're still going through the grounds. And if it is not appropriate for that offender, because of their criminal record, because of violence, to be released, they should not be released. And so I do think that maybe it's perhaps some training in Ontario with Justices of the Peace that are...
Une définition de récidiviste au code.
Could we have maybe a definition of repeat offenders in the criminal law?
Are you asking if that would be helpful? I'm not sure how that would be helpful, because I think that's already applied, but...
Merci, Madame Donker.
Thank you, Ms. Donker. Ms. Kish, would it be useful to have a definition of repeat offenders?
Because the time's up, but just please complete your thought.
I don't think so. I think that you would find that most individuals who would be held under that label would be people who entered the system as youth, who weren't provided with rehabilitative environments, who lacked opportunities. I think what we really need to be focusing on here is why why is violence persisting, why is harm persisting, and we need to be looking at all chains of the justice continuum to address that, and beginning in prisons.
Collègues, il nous reste...
Colleagues, we won't have enough time for a full second round. We'll hear from Mr. Gan and Chang and then Mr. Fortin, and then 5 minutes, except for Mr. Fortin, who will have 2.5 minutes, and then we will need to switch to the second panel. So let's go ahead and start with Mr. Gan.
Thank you, Chair. Start with Ms. Kish. Have you met with any families who have had loved ones murdered by somebody out on bail?
Not murdered by an individual out on bail, but I did have previous employment at an association that worked directly with survivors of homicide.
That's fine. I just want to, same question to Ms. Doncourt. Have you ever met with a family who's had a loved one murdered by somebody out on bail?
Not in that specific instance, but definitely victims of crime.
Same question to you, Ms. Webb. Have you ever met with a family who's had a loved one who was murdered by somebody out on bail?
Not specifically murdered, but I certainly have people close to me who have been victims.
I just wanted to establish that point. I appreciate that. I'll go back to Ms. Kish. Do you believe public safety should be the primary or a secondary concern when it comes to the design of the bail system in Canada?
I think that it's perhaps artificial to associate primary and secondary concerns. I think the concern of the individual, the concerns of the victim, and the concerns of the public are interrelated. And if we adopt a human and a holistic approach to understanding that, we'll have much better outcomes moving forward.
You would say that it would be simplistic thinking to putting public safety first when it comes to the design of the justice system and bail system specifically in Canada?
Not simplistic. As my colleagues mentioned, I think that the safety and protection of the public is always the salient consideration at all processes of our judicial system right now. But what we have is a persistent problem with similar outcomes over time that demonstrates that some things need to change.
Do you believe would be easier or harder for a repeat violent offender to reoffend while they're still in jail?
More difficult, but realistically, can we keep people incarcerated forever? And if not, then let's consider how we're treating them while they're in prison.
But we're talking about the bail system here, so I just wanted to establish that point that we're all on the same page. Do you agree that when you look at a Liberal bill like Bill C-75 that removed, including the principle of restraint, as well as introducing reverse bail onus for serious crimes, would lead to more potentially dangerous criminals remaining behind bars? You can argue whether that's a good thing or a bad thing or not, but just to establish the facts.
I'm not certain that there are any effect from these policies on people who are posing actual danger remaining behind bars. Just from my professional experience, what I see is a system that's so exhausted that it can't properly assess these decisions, and it begins assessing decisions for the wrong reason, for time constraints, for resource restraints, but that there's a lot of really good professionals in the system who want to help individuals who are posing harm, and their hands are tied.
Ms. Dunker, what would you say to, I've spoken to a lot of police officers who are frustrated, who tell me stories repeatedly of arresting the same person over and over and over again, stories of arresting the same person for the same offense twice within a 24-hour period, who are almost putting up their hands and feeling like they aren't being given the tools to do their job.
I would say that we share the same concerns when it comes to public safety. We're certainly not saying, let's sit on our hands and do nothing here about repeat offenders. That's not the case. We want something to be done, but we want effective reforms. And effective reforms are evidence-based reforms. I want to see the evidence. I'm hearing a lot of concerns about Bill C-75 and how that's led to more repeat offenders. I want to see the evidence. I want to see the trends. I want to see the patterns. I want to see what's directly causing this so that we can directly address it.
I'm glad you brought up the evidence. You referenced some statistics from, I believe it was maybe 2024 to 2025 or 2023 to 2024. But there's some other statistics there as well, as far as what's been happening since 2015. Violent crime up by 50%, homicides increased by 27%. Also, interestingly, 35% of those homicides in 2023 committed by a criminal on some sort of release, including bail. So I think if you look at public opinion, you look at the statistics provided by the government since 2015, since this new Liberal government came into power, violent crime is up across the board. So you can cherry pick different regions and different, year over year periods within that. But how do you explain the undeniable increase in crime over the past 10 years?
Go ahead. No, go ahead.
There's about 30 seconds. I'll give you
I'll
some time to
let
finish
Ms.
your
Webb
thoughts, but
address
we have to
this
move on.
so she has the opportunity.
Unfortunately, I know I appreciate that there may be increases in specific types of offenses over periods of time, but suffice it to say that the statistics alone don't tell us specifically what's the cause of that. So unfortunately, I'm unable to comment as to whether, and I would be very reluctant to speculate.
Your position, it's a coincidence?
I wouldn't say it's a coincidence, but I think that there needs to be meaningful analysis.
Thank you. Great job. Mr. Chang.
Thank you, Mr. Chair. Thank you three all for your time. In Burnaby Central, my riding, one of the most diverse ridings in Canada, people from every background want the same thing, a justice system that is fair, firm, and trustworthy. So diversity teaches one thing, that fairness must be at the heart of our approach. But the good people of Burnaby Central also tell me that they want to feel safe in their homes, on the transit, and in their neighborhoods. So the balance between fairness and firmness is important as we study bail and sentencing reforms. Canadians lose confidence when the system seems too lenient, but they also lose confidence if it overlooks equality and charter protections. So my very first question goes to Ms. Kish. The CAEFS emphasized that human rights and dignity should be at the heart of justice policy, including bail and sentencing. So how can bail decision-making better balance these principles with the goal of enhancing community safety?
I'll reiterate that I think that the existing law in the books is strong, and that the problem is what happens to people when we're sending them into prisons. Most of the individuals who I speak to who don't feel safe in various communities across Canada feel a lack of safety because of people in untreated addiction in communities. And talking about how to respond to addiction in society and how these drugs are getting to our streets and talking about prisons should be separate conversations. I think the only reason they're conflated is because right now most people in active untreated addiction end up committing minor or serious crimes and going into our prison system, which is ill-equipped to handle them. So if we weren't incarcerating people for issues of mental illness and addiction, and if we were thinking meaningfully and in distinct ways about these crises we face, then we can tease out why people are being incarcerated, experiencing worse conditions in prison, being released and causing harm again, because prison is not the appropriate response.
Thank you. So my second question would be, conditional release often relies on support such as housing, treatment, and supervision, yet CAEFS has identified gaps in these resources across provinces. So in your opinion, in your view, what are the most significant gaps and what actions should be taken to address them?
Especially post-pandemic, I think speaking to what's causing an increase of crime, if there is one, again, I would point to people having a lack of affordability, a lack of resources, a lack of purpose, untreated addiction, and then worsening mental health crises that flow from all of these things. We know what works. I ended with the anecdote of the story of the individual who found community because it's strangely simple. As complicated as we make the system, when people feel cared for and feel like they have an opportunity to be a better version of themselves and to do something that means something in the world, in more cases than not, they're going to respond positively. Sure, we have a society that will always be imperfect and harm is always possible, but let's invest in what works, which are community-led programs. And in the portion of last week's testimony when the police associations were speaking to cross-sectoral and cross-jurisdictional mobilization, it's true, we can't be working in silos. We all face and all respond to the same problems, so we should be doing it together.
Thank you, Ms. Kish. And my third question goes to Ms. Donker. The Canadian Association of Black Lawyers has argued that social context should be considered in criminal proceedings. So how can that principle help ensure that bail decisions target repeat violent offenders while avoiding unintended impacts?
Well, we do already have Section 493.2 of our criminal code, which is intended to address vulnerable populations, including Black and Indigenous communities, and Black and Indigenous individuals that are disproportionately represented in the criminal justice system. And where that is applied appropriately, that should be a way in which social context evidence can come into consideration in the bail context. And I want to make clear that 493.2 is not a get-out-of-jail-free card simply because you are Black, Indigenous, or marginalized. It is taking consideration of the full picture. And our courts at all levels, including the Supreme Court of Canada, has recognized that racism, in particular anti-Black racism, is a prevalent part of our society, including our institutions, including the criminal justice system. So it is not simply that Black and Indigenous people are more violent, commit more crimes. A part of the reason why we are continually seeing Black and Indigenous people in our criminal justice system is due to anti-Black racism, systemic discrimination that needs to be addressed.
Thank you.
You're pretty much done. Monsieur Fortin, 2 minutes et demie.
Mr. Fortin, 2.5 minutes. Thank you, Chair. Now, I'll ask my first question to Ms. Webb. And young offenders who are committing crimes, we talk a lot about how we treat these people, how we deal with these people, rather. whether to bring them before adult courts. But what I'm more interested in is rehabilitation. I can ask all three of you, but let's start with Ms. Webb. Is it easier to rehabilitate young people? And secondly, those who recruit young people, who are not adults, obviously, to commit crimes, are we cracking down on them sufficiently? Are we creating, maybe can we envisage creating a crime out of the act of recruiting a young person to commit a crime? So is it easier to rehabilitate young people? And secondly, would it be envisageable, in your opinion, to create an offense for recruiters? Ms. Webb.
My apologies. Given that youths, first of all, it's tried to say that youths are treated differently from adults, and they have the Youth Criminal Justice Act for very good reason. They are presumed to have diminished moral culpability or diminished moral
30 secondes, Madame Webb. Je m'excuse.
I apologize, within 20 or 30 seconds, if you can. So should we do more work on rehabilitating young people, and should we create a new category of crime for those who recruit young people?
Very shortly, I absolutely believe that youths can be rehabilitated, and I would certainly hope that they can be rehabilitated more quickly and more efficiently than adults. In terms of adults who may manipulate youth to commit crimes, I would agree that that is a matter for serious concern, and certainly I think the committee could study that. And
Merci. Ils ont depuis de temps. Madame Dunker,
Thank you. Unfortunately, I don't have a lot of time. Ms. Donker, what do you think on the same question? Or Ms. Kish, if you want.
I think that, unfortunately, as previous testimony recognized, most of the people who end up in our prison system are young people, and we should invest all resources to protecting people while their frontal cortexes develop. If we create an offense that creates a longer sentence for people targeting youth to crimes, provincial prisons especially are breeding grounds to recruit people into further gang and criminal activity. So what mechanism do we have to respond to people who are behaving in these ways? It's an important conversation.
Merci, Monsieur Fortin.
Thank you, Mr. Fortin.
Has quickly come to an end. I want to thank all three of you for your testimony and the respectful participation of the members with the witnesses, and look forward to seeing you here once again. But thank you for the time, even though it was short today. Thank you. We'll take a few minutes. Thank you. Welcome, everyone, to the second hour. Our panel today, and we were just finalizing Mr. Roskamp online, and he is here. That's who we know. Today we have with us from the Canadian Civil Liberties Association, Shakir Rahim, the Director of the Criminal Justice Program. From the John Howard Society of Canada, Catherine Latimer, Executive Director. And online, joining us remotely, Chief Mark Roskamp from the St. Thomas Police Service. Without further ado, we will start with 5-minute presentations in the order that I presented the witnesses, and then we will get off to the round of questioning. Thank you very much. Please go ahead, Mr. Rahim.
Good afternoon. I'm a lawyer and Director of the Criminal Justice Program for the Canadian Civil Liberties Association. I would like to begin today by telling you the story of Umar Zamir. 4 years ago, Mr. Zamir was charged with first-degree murder. On a night out in Toronto, with his pregnant wife and 2-year-old son, he was approached by people in civilian clothing in a parking garage who had their guns drawn. He panicked, drove away, and unintentionally hit one of the men, who turned out to be an undercover police officer and tragically passed away. Mr. Zamir was released on bail, and there was outrage. A premier called it an example of a criminal having his life put ahead of victims and families. A mayor called it disgusting and a disturbing decision. 2.5 years later, Mr. Zamir was acquitted by a jury on all charges in what was widely viewed as a weak case that never should have been brought. What stood between Mr. Zamir, an innocent man, and a prison cell for those 2.5 years? Bail. Mr. Zamir's story uniquely grabbed the headlines, but his story is not rare. Roughly half of criminal cases in Canada do not result in a finding of guilt. But for pretrial release, innocent people would lose their jobs, the ability to see their loved ones, and their liberty, despite having committed no crime at all. And bail has become more, not less difficult to obtain in Canada over the past 50 years. According to Statistics Canada, 22% of people in provincial and territorial prisons in 1978 were denied bail. When Bill C-75 was passed in 2019, that number had tripled to 67%. Last year, across Canada, it stood at 76%. And while the number of people imprisoned because they were denied bail has skyrocketed, conditions in provincial and territorial jails have plummeted. In 2025, the Ombudsperson of Ontario found provincial jails there in a state of crisis, with severe overcrowding and frequent lockdowns. Similar observations have been made in other jurisdictions. In these dire conditions, the innocent may plead guilty simply to get out, and others will leave with trauma that will imperil their rehabilitation. So how do we reconcile this reality with the headlines that we see about bail? First, critically question the notion that bail is driving an increase in crime across the board. For example, again according to Statistics Canada, charges for motor vehicle theft and break-and-enter offenses are down approximately 10% since 2020 and around a full third since 2010. In Montreal, gun violence has decreased 47% since 2021, according to the SPVM. In Toronto, as you have heard, shootings and firearm discharges are down 40% this year, according to the Toronto Police. This September, the mayor of Vancouver announced that violent crime in his city was at a 23-year low. Second, effective bail reform requires us to be able to identify and measure where problems may lie. Yet no jurisdiction provides standardized data on the number of people who allegedly reoffend while on bail, their charges, and their release conditions. That data would also tell us about the many bail releases where people do not reoffend, people who abide by their conditions. Those cases, too, must be taken into consideration when it comes to bail reform. It is vital that the federal government... Yes.
You to wrap up?
Absolutely. Last sentence. It is vital that the federal government, in collaboration with the provinces and territories, collect and publish standardized data to ensure any future changes are grounded in evidence. Thank you.
Thank you. Ms. Latimer.
Can you hear me now?
You're fine.
Thank you. It's a great pleasure to be here, and John Howard Society is very grateful for the invitation to come and contribute to the to this important study into bail, sentencing, and the handling of repeat offenders. The John Howard Society of Canada is a national charity committed to just, effective, and humane approaches to the causes and consequences of crime. Affiliated John Howard Societies provide services in more than 60 communities in all provinces across Canada. We are guided by principles and evidence relating to just, effective, and humane approaches to reduce crime and make communities safer. In these opening remarks, I would like to comment briefly on repeat offending and sentencing before focusing on bail reform. The criminal justice system is really very familiar with dealing with repeat violent crime. And there are many avenues by which it now deals with it, including progressively longer sentences, less access to bail and community-based sentences, barriers to conditional release, post-release Section 810 orders, and designations of long-term offenders and dangerous offenders. Those found by the courts to be dangerous offenders can remain in prison until they die. Evidence on the effectiveness of these provisions should be provided before further measures are adopted. While the penalty reflects the seriousness of the crime, studies show that tougher penalties do not deter crime generally, and so will not be effective in making communities safer. From our perspective, more needs to be done to reduce repeat crime. We note all party support for the federal framework to reduce recidivism and believe it to be an important tool, but underutilized for reducing repeat crime. The Minister of Public Safety's report to parliamentarians on the first 3 years of progress is due, and will be followed by annual reports on the framework. Parliamentarians have a key role in helping to shape government efforts to reduce repeat crime through the federal framework to reduce recidivism. Any study of repeat crime would be incomplete without examining this vehicle and how it can be useful to that end. I would point out, as some was raised before the earlier panel, that the combination of increasing homelessness, drug addiction, and mental illness has made forms of problematic behavior more visible in some communities. Police and others do not have adequate resources to quell public concerns about how often criminal behavior that is not serious enough to warrant serious criminal consequences are treated. Some believe that this is maybe what is fueling the catch and release concerns. I think people share the concerns of people from Surrey that they want to feel safe in their communities and are troubled by erratic behavior that they see on their streets. Much more needs to be done to address the underlying causes of this behavior and to provide services for those in need. Sentencing reforms. The instinct, and I've noticed this in earlier panels, is to increase sentences to address concerns about increasing crime. Studies show that tougher penalties do not deter crime. John Howard Society believes that the quantum of the sentence should reflect the seriousness of the crime and the person's degree of responsibility, not more than that. We oppose mandatory minimum sentence because they are always unfair to those whose degree of responsibility warrants a penalty that is less than the minimum. In terms of the bail system, our position is that it is dysfunctional and in need of significant reform. We are very grateful for the analysis and comprehensive reforms suggested in a recent paper by Richard Barnhorst, a copy of which I'm more than happy to provide to the committee. At the outset of his paper, he identified a number of problems with the current pretrial detention and release system. I have listed about 19 of them, but I'm not, if I go into them, I'll be over my 5 minutes. So suffice it to say that there's a lot of problems with collecting the evidence. There are significant delays in the process. There are certain inconsistencies in the application of the pretrial detention provisions across jurisdictions. And as Shakir has pointed out, the numbers of people who are in pretrial detention has been consistently increasing in a manner that does not reflect increasing crime rates. There are significant problems with the pretrial detention provisions, and they call out for reforms. The John Howard Society of Ontario has just released a study in which it was looking at how the province of Ontario could improve remand in its province. And it is looking basically at increasing programs like bail verification programs.
Latimer, if you could just conclude, please.
Sure. We're very grateful that the committee is conducting such a study into how law reform and other measures could effectively respond to crime in a principled and effective manner. And we urge that any immediate reforms to bail be accompanied by a commitment to a comprehensive, principled, and evidence-based overhaul of pretrial detention and release practices, laws, and policies. Thank you very much.
Before we go to Chief Roskamp, we just need to do a brief sound test, if the committee can bear with us for a second. Heard properly and the translation's working? That's the first part of the test. Okay, we're going to call him.
Can you hear me now?
Yes, we can. Could you hear me?
I can hear you, sorry.
We can hear you. Translation will confirm that you're being translated. Thumbs up means we can hear you in both official languages. So, yeah, please go ahead. You have 5 minutes, Mark.
Well, thank you very much for the invitation and the opportunity to speak with you today on matters of deep concern to police leaders across Ontario, across Canada, the urgent need for meaningful and balanced bail reform. As the chief of the St. Thomas Police Service, a small to mid-sized growing community in southwestern Ontario, I appear before you not only as an Ontario police leader, but as a voice for St. Thomas residents, families, and business owners who are living with the consequences of a system that in its current form is failing them. The core issue is this: our communities are increasingly and consistently being harmed by individuals who are repeatedly released into the public while facing serious charges, only to reoffend, often violently, while on bail. Pretrial recidivism and chronic criminality are not abstract concepts. They are daily realities for frontline officers, for victims, and for communities who are, quite frankly, begging for police services for relief from violence and disorder. It is important for me to be clear. I respect the constitutional rights of every individual, including the right to reasonable bail and the right to a timely hearing. These rights are foundational to our justice system, and as police officers, we uphold them with the utmost seriousness and respect. But constitutional rights do not exist in a vacuum. The Charter does not stop at the accused. Our law-abiding citizens also have rights. The rights to be safe in their homes, in their streets, in their places of work. Police have fundamental obligations to protect the public. That is our duty and that is our promise. And what we are seeing, however, is the implementation of legislation such as Bill C-75 and Bill C-48, they've created a system in which that promise is increasingly difficult to fulfill. The practical application of these laws, particularly around bail provisions, has weakened judicial accountability and too often prioritized procedural fairness for repeat offenders over the broader safety of our communities. The result is that violent and or chronic offenders are released multiple times before facing trial. Chronic offenders with long histories of victimizing others, including vulnerable individuals and small business owners, continue to cycle through the system without meaningful intervention. Our communities feel abandoned by the very institutions meant to protect them. There's a growing and dangerous disconnect between legal theory and lived experience. Simply put, there is a lack of common sense left in the current bail regime, and it is our communities that are paying the price. We are also seeing a concerning and troubling trend: the automatic attribution of all criminal behavior, or some, to the broader social and health disorders that are occurring. While no one disputes the impact of social determinants of health on individuals, and while police are among the first to advocate for proper compassion, health, substance use, and social supports, we must not allow these challenges to be used as a blanket excuse for serious, planned, and repeat criminal conduct. Too often, individuals who are prolific, repeat, and strategic are treated in court as though they are first-time, low-risk individuals. This is a profound disservice to the communities they repeatedly harm. It erodes confidence in the justice system and fails to deter criminality. We cannot continue down a path where those who habitually harm others are granted the same consideration as those facing their first charge under exceptional circumstances. That is not justice. That is a loophole, and it's one our communities are falling through every single day. Today, I won't speak to a return to overly punitive systems of the past. We are calling for a return of balance, a return to a system that recognizes risk, prioritizes public safety, and gives meaningful weight to the rights of victims and law-abiding citizens. That means real, effective judicial oversight. It means ensuring that high-risk offenders are not continually released without accountability. Chair and members, we're at a critical juncture. We need your leadership. We need bail laws that protect our constitutional values while also protecting our communities. Thank you, and I look forward to your questions.
Encore une fois? C'est la traduction ou c'est... OK. OK, parfait. Non, parce que je l'avais éteint moi-même.
No, I turned off my mic.
For that, and Ms. Latimer, Mr. Rahim, for your testimony. We will go back to round one with MP Lawton leading off, followed by MP Latanzio, and then obviously Monsieur Fortin. Andrew, the floor is yours.
5 minutes or 6, Chair?
It's 6 minutes for the first round each.
Thank you.
And then 5, 5, and 2.
Thank you to all the witnesses for taking the time to join this very important study, and thank you, Chief Roskamp, for your testimony. I'd like to start with you, because we heard witnesses earlier in this meeting say that the instances of criminals committing crime on bail are outliers. That was the exact word that one of them used. That when criminals commit crimes on bail, they are outliers. Is that your experience on the ground as a police officer, Chief Roskamp?
That is not my experience. The vast majority of individuals committing criminal offenses today are doing so pre-trial in a pre-trial recidivist way.
Just for context here, St. Thomas is a small community, but relatively speaking, fewer than 50,000 people. What is the volume, if you had to estimate, of these prolific offenders, these individuals that you would attribute to engaging in chronic criminality, and what is the burden that your police service is shouldering as a result of those individuals?
That's a great question. I can give you some statistics. Between 2022 and 2025, our police service laid approximately 7,500 criminal code charges. Of those 7,500 criminal code charges, 2,000 were failing to comply with court disposition. Consistently, year after year, we see about 33% of our charges being failed to complies. We have numerous individuals in our community, whether it's intimate partner violence or whether it's chronic criminality from small petty theft, petty crime, up to homicide. We're seeing fail to complies as a major pressing point, and individuals, offenders, understanding the legal system well, they know that bail conditions are rarely enforced. They anticipate delays in the court proceedings. They recognize that even serious charges may not lead to long-term detention, and in fact, it's what we're terming like they're gaming the system. And so, I think that is there any other areas you'd like answered in regards to that, Mr. Lawton?
I think you've addressed the question very well there. What I'm trying to get a sense of is, and you've indicated it there, so nearly 1/3 of all the charges you laid in that particular period of time were bail violations.
Correct.
So explain to me, if you can, Chief Roskamp, the effect this has in particular on smaller communities. Because I know historically, 10 years ago, for example, before the Liberal government formed, there was an attitude in St. Thomas and communities of similar sizes across the country that basically these were all big city problems. And now we've seen this trickle down. So what is the effect on your resourcing, given that you are so comparatively smaller than the Torontos and the Vancouvers of the country?
This is a great question. The rise of violence and chronic criminality in small communities, it has far-reaching effects, and it creates widespread fear and trauma in communities and undermines the safety, a sense of safety of our residents. Violent incidents can reduce investment. It can harm tourism. It can increase municipal budgets. It increases municipal budgets, my budget as a police service. And over time, the community's identity shifts. We had between 23 and 24, 22% increase in our crime severity index. Although we had among, a national high and the reduction of non-violent crime severity, that's your break and enters, your mischiefs, your minor thefts, 32% reduction. And so we're proud of that, but it's such fragile gains that we have to be careful. And we're looking at this chronic criminality as being such a pressure point for smaller communities. In 2024, we unfortunately experienced 2 homicides. One of those homicides, a young lady was shot and killed in a parking lot in a downtown corridor. The individual that's alleged to have committed this crime was out on bail. And so it affects communities of all sizes. You do not have to be in large metropolitan centers or in the GTA for this to affect your community. And we're seeing that, and that manifested in a big way post-COVID, that chronic criminality, and it has lasting serious impacts on communities.
You mentioned, Chief Roskamp, in your opening statement, 2 bills specifically, the Liberal bills C-48 and C-75. Can you draw a direct line between that legislation and the problems you've been describing?
Simply put, I believe C-75 has created less safe communities. Is my opinion, near 30-year career in policing. Releasing individuals at the earliest opportunity with the least onerous conditions has gone too far. It does seem as though almost every individual who faces the court system is released. And to be quite honest, offenders know this, and that's part of the gaming that's occurring today, and that's real. Our main criticisms of C-75 are that it removed tools that allow judges to account for long-term criminal history and compliance behavior, resulting in more frequent releases. 48 was a step in the right direction, but it had gaps. It didn't allow for judges to consider anything beyond 5-year limitations with regards to prior convictions. And so we're left with the position we're in now. All we're asking for is better court-level decision-making frameworks. among other areas, and I can get into those if you'd like. With regard to
That'll
our
have to be
suggestions.
with another member of Parliament. Thank you for your time, Chief Roskamp.
Thank you.
Without blowing up your computer, if you could maybe turn up your volume or speak louder on the next round, but I'm projecting on you because we're relatively the same age and I assume we have the same computer skills. I don't want you to disappear by pressing the wrong button, so I use your judgment. Ms. Latanzio.
Thank you, Mr. Chair, and thank you for the witnesses for being here today and participating in this very important study. I will address my first question to you, Mr. Rahim. In March of 2023, the Canadian Civil Liberties Association said bail debates were being driven by rhetoric rather than evidence. From your perspective, why is it so important that Parliament keep its focus on evidence-based reforms rather than slogans?
Because that is actually what is going to lead to an improvement in public safety. To simply not look and collect the data about the patterns we have seen means that adjustments to the bail system won't be able to be properly assessed or implemented. And, the Senate Committee on Legal and Constitutional Affairs, in its study of Bill C-48, made this exact point. They said it is time, long past time, for us to collect data about the system. But yet between then and now, we have not seen any new information to help inform policymakers like Mr. Chair, the ones here today, to make decisions that are rooted in evidence. That's how you ensure we have the right balance between the presumption of innocence and those other charter rights, and as well, public safety.
Thank you. My next question will be addressed to you, Ms. Latimer. So in your view, how should provinces and the federal government work together to ensure that enough judges, Crown prosecutors, and correctional resources to make bail reforms meaningful in real-life, day-to-day practice?
I think it's always a challenge working across jurisdictions. I think some of this has been the Premier is pointing at the federal government thinking that legislative reform alone will actually correct some of the manifest problems in the bail system, and it won't. It will require collaboration, more programming, and the supports in place to make the system work. The delays are too long. People are subjected to conditions in the community for too long. They're subjected to remand for too long. There's too many delays in the system. The whole system needs to improve. But more importantly, there needs to be programs in place that help people respect their bail conditions, so you don't have to lay as many non-compliance charges as they are clearly in some communities, because people are showing up for their bail hearings. They're respecting those conditions, and some of the bail verification programs have proven to be very successful in helping that. So have bail navigators in Manitoba have proven to be very, very successful in helping people to comply with their conditions. But it will take an effort across all jurisdictions to really make the changes that need to be made to a very dysfunctional system at this point.
Thank you. Camp, do you believe provincial courts have the adequate capacity to conduct timely bail hearings and risk assessments?
That's a great question. Would we like to see more court time and more time given to conduct bail hearings? Yes. So the answer is we would like to see more time given to this area and more consideration given on safety risks.
But more specifically, in terms of provincial courts, do you think that they have the capacity to be able to conduct this work?
There's always room for improvement in that area.
Okay, what would you suggest? What would be your recommendations?
Well, I would suggest that more resources be put towards our provincial courts, more judges, more Crown attorneys, perhaps longer hours in courts.
So do you believe that this is a joint effort with regards to different levels of government, provincial, municipal, and federal?
Yes, I do.
Okay. I'm going to go back over to you, Ms. Latimer. Public confidence in bail often comes down to whether conditions are enforced properly. Based on your experience, what steps would strengthen the system so that people released on bail are supervised consistently and safely?
I think there's a lot of challenges with the enforcement of the conditions, the sureties, who's monitoring the sureties. Do people actually lose their money if they do not adequately discharge their responsibilities? And monetary sureties do have a very strong class bias in that those from less affluent positions are less able to enjoy the liberties that others equally entitled are enjoying. So yeah, I think there needs to be a reworking of bail supervision capacity so that those who are released on bail are adequately supervised and supported so they meet those conditions. And I think the whole system needs to be streamlined so that it focuses remand on those who actually pose the most significant risk and not on many of the people that we see languishing in very unfortunate conditions awaiting trials and for far too long. So I think you need to have a system that really focuses on those who may well present a serious risk to future criminality and to the public and find constructive alternatives for the rest. And I think that would be a big help.
Thank you.
Merci, Monsieur le Président.
Thank you, Chair. Thank you to all of our witnesses, Mr. Rahim, Ms. Latimer, Mr. Chief Roskam. So thank you all for being here. My questions will be for Chief Roskam to start, just to make sure we're talking about the same thing. Would you say that, do you believe in rehabilitation or not?
Chef Roskam?
Chief Roskam?
The translation?
Oh, Monsieur le Président, vous allez arrêter mon...
Chair, I hope you're pausing my time.
So, Mark, if you just go with You're also frozen on screen, so it was fateful warning for me. But if you go to the interpretation button that looks like a globe, you can click on it, and since Monsieur Fortin is speaking in French, you press English.
Got it. Thank you.
Problem. Ouais, répète, puis on a gelé ton...
Okay, I'll start again. Mr. Roskam, hello. Do you believe in rehabilitation?
Est-ce que vous m'entendez, Chef?
Can you hear me, Chief?
Geez, I'm still not getting a translation. And I've clicked it.
If you press interpretation, the check mark should highlight where it says English, whereas it probably says original with a check mark on it.
Chair, I have check marked English.
Okay.
Alors, je reprends.
Okay, I'll repeat my question. Mr. Roskam, I've been trying to say hi for a while now. Thanks for being with us. And my question is, do you believe in rehabilitation?
I seem to have some technical difficulties here. I have clicked the English translation, but I'm not hearing translation through my headset. My apologies.
Let's just pause for a second and see if we can do a quick fix, Chief Roskam.
Thank you.
Ask him to disconnect and reconnect. With the connection.
that, again, may be famous last words, but if you click out of Zoom and then click back in, maybe that'll fix it. And if not, we'll just have to figure out a workaround. Otherwise, serais-tu prêt à poser tes questions aux autres témoins?
Would you be ready to ask your question to other witnesses? Well, I really wanted to ask my questions to Chief Roskamp. Not that our witnesses here are not important, but my challenge lies in this direction for the most part. If that's the case, we can just make a note in the report.
right.
French, and I'm hoping that it works for you. Do you understand what I'm saying right now?
Mark, did you hear what I said in French? Okay, now.
I heard French, yes,
okay,
sir.
perfect. But you heard French, but you didn't hear the English translation of it.
I did not hear the English translation.
And did you select the English on your...
Could you try one more time?
Bonjour, Monsieur Roskamp.
Hello, Chief Roskamp. This is the chair of the committee.
Extend the time, the length of whatever the snafu was, and okay. Yeah, so let's do. So it was about 10 minutes. Vous aviez 5 minutes, Monsieur Fortin.
Mr. Fortin, you have 5 minutes for your questions.
Oui, vous avez 6 minutes. Il restait 5 minutes.
Yeah, you still had 5 minutes. But I didn't even get to start asking any questions. I mean, I want to play along, but I'd like my 6 minutes ideally. Okay, go ahead. Hello, Mr. Roskamp. Can you hear me this time around? So thank you for being with us. Now, the question I have for you initially is, do you believe in rehabilitation?
Yes, sir, I do.
Et pour vous...
So for you, when we talk about young offenders under the age of 18, do you think that rehabilitation is easier for these people compared to older folk?
Just so I understand the question correctly, do I understand that rehabilitation is easier? Is that what the question was, sir?
Oui, c'est à savoir, est-ce que c'est plus facile avec...
I just want to know if it's easier to achieve rehabilitation with young offenders.
I think it probably is. Yes.
Monsieur Chef
Chief Roskamp, the criminal law as it is currently envisages that people are set free if you will, and then they're supposed to come back and appear before the court. Now, if they don't come to court, or if it is judged that it's easier, it's better for public safety, and if it's dangerous people, or in a third case, if this would shock the public opinion given the severity of their alleged crimes. Now, these criteria, do you think they're adequate, or should there be changes made to these criteria?
I think there should be changes made to the criteria. We need to acknowledge root causes where relevant, read the social determinants of community health, and those suffering from homelessness and poverty, substance use disorders, and mental health disorders.
Mais qu'est-ce qu'on devrait changer dans les critères?
But what should change in these criteria? Because currently people are kept in pretrial detention if they're dangerous to the society, or if there is a belief that they will not appear before court, or the third criteria. So that's what we have currently. But I'm inclined to think that these are good criteria, but maybe that's not the case. So what needs to change in these criteria, in your opinion?
I would suggest respectfully that in the majority of cases, that's not happening. And for chronic, strategic, and violent repeat offenders, we're looking for consideration, much more consideration to be given for public safety, offender accountability, and stronger judicial discretion, giving judges the ability to make those discretions sooner, not releasing at the earliest opportunity with the least onerous conditions.
Merci. Je vais changer de sujet, monsieur.
Thank you. I'll change subjects, Mr. Roskamp. Now, speaking of young offenders, we're seeing more and more criminal organizations who are recruiting young people to commit crimes. Auto theft, for instance, has been on the news, and even violent crime, with the belief that these young offenders will not be facing adult criminal justice system. But I find this outrageous. My question is the following: what do you do with young people in these situations? Should we try to keep trying to rehabilitate them? And especially, what do you do with the adults who incite young people or recruit young people to commit a crime? Should we not be cracking down on these adults who are recruiters? I think I have less than a minute, so the floor is yours.
Yes, sir. First of all, with the youth, we should do all we can to rehabilitate those youth and to try to turn their lives around and help them lead healthy pathways in society. In terms of those that are inciting and driving these serious crimes, for which St. Thomas is even a victim of in recent days, we need to seek out those individuals and hold them accountable to the law.
Si on disait, si je vous proposais.
So if I suggested double the sentence for someone who is recruiting a young person to steal a car, double the sentence compared to the sentence they would have received if they stole the car themselves, is that reasonable in your opinion?
Absolutely.
Merci, Monsieur Roskamp.
Thank you, Mr. Roskamp. I don't have a lot of time, but Ms. Latimer, on your end, what do you think needs to change in terms of the criteria of keeping an accused in detention?
I think there needs to be a refocusing so that I think the criteria on the first two, like likelihood of absconding and whether they'll commit an offense if released, are good. Predictive behavior is always challenging. I think the best predictor is looking at recent past behavior. So if they're in a crime cycle, I think you need to keep them detained in the interest of public safety. I think the problem is that you're getting far too many others who are in there for less serious reasons, and you need to have it's an expensive system and a dysfunctional system when you do that. You need to find constructive alternatives to help people respect their conditions so that they can appear before court for their trials.
Merci tout le monde. Désolé.
Thank you, everyone, and apologies, Mr. Rahim, I didn't get to ask you a question.
Into the second round with the extension, we should be able to complete a full second round if I shave a minute off each of the last two, each being liberal and conservative. It would give 5, 5, 2.5, 4, and 4, if that's okay.
Termine pas à 5h30?
Non, mais on avait convenu.
Well, we agreed to continue. Because of the interpretation issue we had. Because of me. Because I speak French.
So starting off, Mr. Brock, then Briere, Monsieur Fortin, MPs Gunn, and then Dillon.
Thank you, Chair. First question to you, Mr. Rahim. Thank you for reminding us about the tragic consequences of the Zamir matter. I'm going to ask you some questions about that, and if you have the answers, it would be much appreciated. To your knowledge, sir, did Mr. Zamir have a criminal record? Okay. To your knowledge, did Mr. Zamir, at the time of the tragic consequences, was he on an interim release already?
He was not.
Okay. And to your knowledge, sir, during the period of time by which he was on bail or judicial interim release, the formal legal name, were there any allegations of breaching of that order or bail?
There were not.
No. So in my view, the system worked as designed. The vast majority of individuals who are charged with criminal offenses, and I would dare say probably in the high 80th percentile, low 90th percentile, are not the type of individuals that we as the Conservative Party are concerned about. We are concerned about repeat violent offenders who are reaping the benefits of a soft on crime liberal agenda. My next question to you, Chief. Chief, for 4+ years, you have been part of a body of law enforcement and leaders right across this country, including premiers, including mayors, including victim advocacy groups who have been pushing this liberal government to change their soft on crime bail laws, all to no avail. You were promised relief under Bill C-48. That did not move the needle one iota in terms of curbing the behavior with these repeat violent offenders. So today, actually last week, we introduced in the House of Commons the Jail Not Bail Act, and today, on one of our opposition motion days, we started to debate that. So I'm going to be asking you some questions and your thoughts on some of the key features of the Jail Not Bail Act. We're wishing to replace the principle of restraint under 493.1 with the principle of protection of the public as the priority in judicial interim release hearings. Do you support that, Chief? Chief.
Yes, sir, Mr. Brock.
I didn't hear the answer.
Mr. Brock, my answer to that is yes.
Okay. We are adding several violent indictable offenses to the list of reverse onus offenses at subsection 515 sub 6 for the determination of judicial interim release. Do you support that?
Yes, I do.
We're going to create a list of major offenses composed of violent reverse onus offenses. Do you support that?
Yes, I would.
We're going to prevent those charged with major offenses from being released after arrest by a peace officer. Do you support that provision?
Could you repeat that?
We're going to prevent those charged with a major offense from being released after arrest by a peace officer. We want those individuals to go to court. Do you support that?
Absolutely. Yes, I do.
We're going to require that only a Superior Court judge on a reverse onus basis, whether to permit the interim release of an accused charged with a major offense while the accused was on release in respect of another major offense, and if the accused was convicted of a major offense in the last 10 years. In essence, treating that class of individuals under Section 469 of the Criminal Code that only a Superior Court justice can entertain the judicial interim release application. Do you support that?
Yes, I do.
Do you support the provision that we're going to provide that on the expiry of the interim release of an accused upon their conviction of an indictable offense while they await sentencing?
One more time, please.
That judicial interim release will not be available to those convicted of an indictable offense pending sentencing.
I agree with that, yes.
Do you agree that prohibiting those with a conviction for an indictable offense in the last 10 years from being named as a surety?
Yes, absolutely.
Thank you.
Madame Brière, la parole est à vous.
Merci beaucoup, Monsieur le Président.
Thank you, Chair. I'd like to thank all of our witnesses. This was indeed very interesting. Mr. Rahim, I especially enjoyed your introduction and your account of that particular situation. Now, since the beginning of this committee meeting, we have been hearing all sorts of numbers and positions. Of course, you can make the numbers say whatever you want them to say. But on the other hand, I think we all agree that we want to have safer communities. And we heard from you, from Ms. Latimer, and from Ms. Doncor from the first panel that there doesn't seem to be that many repeat offenders, or at least the system seems to be able to respond to a certain degree. Do you think that bail is now seen more as a right than a privilege?
I would say that what the data tells us, based on the number of people who have been denied bail, is that the right to bail has in fact been weakened. There are many people who are repeat offenders who are regularly put behind bars in Canadian prisons. It is not unusual. That is why that data piece is so important. So we can look at, okay, here are some of the high-profile cases we've seen. What was the issue there? Was it a risk assessment issue? Was it the conditions? Was it the plan of supervision? Can we find patterns in those cases? And then, armed with that information, how do we make adjustments to resourcing and the law to stop those situations from happening? But that is different than the sort of categorical reforms that one member just mentioned, which do not take into account those individual variances, distinctions, and patterns, but instead restrict bail and its access for everybody, including the innocent.
Merci beaucoup. Madame Latimer, j'aimerais vous...
Thank you very much. Ms. Latimer, I'd like to hear your opinion on the same question as well. You said in your opening remarks that people have less access to bail, but more needs to be done to prevent repeat offenders.
I think that's true. The numbers are very alarming, particularly if you look at them in the international context. Most first world countries have considerably smaller proportion of their overall prison population in remand than Canada does. We're lagging on that. We're sort of, it's not, our numbers on that are not particularly good, which means we've got too many people in the remand system. Now, the question then becomes, do we have the right people in the remand system? Why is it taking so long? Are there delays that make our numbers look bad? What exactly is the problem? And I agree with Mr. Rahim that the numbers and the evidence is not clear. The database on which to make these judgments about how to effectively reform the remand system is not there at the moment, and we need the evidence in order to participate in meaningfully in a comprehensive overhaul, because the system is not working now on either end.
Et d'autres, au cours de...
We had other studies over the recent years here at the Justice Committee, and we heard from many witnesses what you were just saying. They were saying that more severe sentences do not have the deterrent effect that is often desired. So how can you reconcile all of this, bail on the one hand and then sentences on the other?
Well, in the bail process, people are presumed to be innocent. They haven't actually been convicted, so they haven't actually been sentenced. So while people are in remand, they ought not to be getting rehabilitation because they haven't really technically committed any crimes yet. So they're just warehoused, essentially, under very difficult circumstances for way too long periods of time. I think when you're talking about post-conviction and you're dealing with rehabilitation and trying to reintegrate, I think there's a lot more that we can be doing and should be doing. I am a very strong supporter of the government's federal framework to reduce recidivism, which would deal with some repeat offending. Now, that was introduced initially by a conservative backbencher, but it was embraced by all parties. So I think there's common ground here to try and ensure that repeat crime is addressed. But you can't make the assumption that people that are remanded have been convicted or are guilty of an offense. They're technically innocent, and they should be treated that way.
Non, c'est complet.
No, your time is up, Mr. Fortin. 2.5 minutes. Thank you, Chair. 2.5 minutes, so I don't have a lot of time, but my question is for both of you. So a repeat offender. Now, we're going to talk about conditional release or bail, rather. So a repeat offender who has already committed a similar crime that is appearing before a court, should there be a different set of criteria that come into play? I mean, should the emphasis be placed on keeping this individual in prison? And if yes, after how many repeat offenses should a different set of criteria come into play?
Go ahead.
If you look at the bail judgments in those situations, you will see that there is specific weight placed on the fact there have been prior offenses when applying the public safety criterion. So what I would say is that it is about ensuring, and of course there are abilities to appeal.
Je m'excuse de vous bousculer, mais on n'a plus de temps.
I apologize, we're running out of time, but I know it's taken into account. My question is, should it be a criterion? If you are a repeat offender, you are not getting released, you're not getting bail, and if yes, after how many prior offenses should that happen?
A numerical cutoff, it should be the role of a justice of the peace or a judge to analyze the record and make that determination.
Merci. Madame Latimer, vous?
I agree with my colleague here. It really depends on the individual, and it really depends on how old the criminal record is. I mean, a criminal record that's 5 years out of date, the person is just as likely to be committing an offense as you or I after that point. So it shouldn't bear on it.
Le système actuel de remise en liberté, les critères.
So in the current system, the current criteria are good criteria in your opinion, and they don't need to be changed? Is that what I should understand?
I think there needs to be a lot of judicial education and perhaps some Crown guidelines and perhaps a lot of other things.
Je m'excuse, Madame Latimer. On s'entend là-dessus.
I apologize, Ms. Latimer. I do understand that, yes, there's more need for more education, but I'm referring to the criteria. So are the criteria good? Do we change them? I mean, I understand it takes more work.
If they are to be changed, we need that data first and then can evaluate that question effectively.
Merci beaucoup.
Thank you very much. We have two members, MP Gunn and MP Dillon.
Thank you, Chair. Chief Roskamp, is Canada currently releasing repeat offenders out on bail that are a threat to public safety?
I believe in some situations they are.
In Vancouver, just a couple years ago, there was a report that 40 individuals, prolific offenders, were responsible for over 6,300 incidents with police in just a small period of time. In your estimation, what percent of crime that's being committed in your community is being committed by a small number of criminals, repeat offenders, or individuals already well known to police?
It is a very high percentage. I would say it is above 80%.
And you know, that percentage, 80%, I think that's what leads a lot of Canadians, members of the public, to refer to our justice system as a revolving door. What do you think are the main causes of what many Canadians perceive to be a catch and release system?
Well, I think it's a number of factors come into play. And I think in all communities, and I will speak for my own community, a smaller community, post-COVID, the second order effects, those responses that the government took to address life after COVID has affected and manifested these social determinants of health where the resources are just not readily available for individuals who need the supports they need. Therefore, individuals are living in chaos. And when you live in a constant state of chaos, chronic criminality seems to manifest. And so chronic criminality, not enough services to support individuals in a right care, right person approach has created a system where we have that 80%, where individuals are hungry, so they're stealing. Individuals are desperate, so they become involved in the drug subculture. Now we end up with weapons and violent offenses and firearms acquisition. And we're seeing not only those individuals and not only individuals who are seeking out firearms, but have a higher propensity to use them. And we had 2 incidents in my town in the last month, 2 armed robberies. One was at a bank, and one was at a restaurant. These types of crimes didn't happen in St. Thomas years ago. They seem to be happening at a remarkable rate these days, and it has all of us concerned.
Chief, do you have members on your force, rank and file, that are frustrated that they are having to arrest or detain the same people over and over again for the same or similar offenses?
Yes, sir.
Do you believe that when it comes to this problem with repeat, prolific, violent offenders, that the Liberal plan to confiscate thousands of firearms from law-abiding gun owners will help improve the problem in St. Thomas?
No, sir.
Do you believe that confiscating firearms from law-abiding gun owners or cracking down on repeat offenders is a better use of your finite police resources?
Enforcing chronic criminality, finding solutions as supported by the federal government at all levels of government, provincial as well. But that is the best use of our time. Our communities deserve to be safe and to feel safe. As was just recently mentioned in a previous question, communities plagued by chronic criminality, safety seems to have become a privilege instead of a fundamental right. And as such, we're failing our communities, and our communities deserve better.
Ms. Dillon.
For witnesses. I'll start with you, Mrs. Latimer. You mentioned just before in your testimony that bail is not a one-size-fits-all solution. You also have to see how long the person was last in jail or on bail. My question to you, if somebody keeps committing crimes, is a recidivist, keeps getting arrested back-to-back consecutively, why do they keep getting let out on the streets? This is something we don't seem to be grasping. Can you please explain a little bit? Why do we see that?
Sure. If I could just get a clarification, are you talking about pre-conviction for the offenses or post-conviction?
Sometimes they said they were out on bail. We keep hearing this over and over. They were out on bail. Can you please tell us why a judge would let somebody out if they've continually been doing back-to-back?
I think it's one of the problems with the bail system in that the criteria that's being applied and how it's being applied, it's not entirely clear to those of us outside of the system how we're getting such an apparently unfair system. And I would say a marker of the unfairness is the actual numbers of people who are remanded in custody who may not need to be there at all if we had adequate support programs for them in the community. So we do need an overhaul. We do need the data. And we need to figure out how to get this right so that people feel comfortable. I'd be better able to answer your question about post-conviction recidivism, which is a different answer. But people go through crime cycles, and you need to stop those crime cycles in order to support their rehabilitation.
Thank you. I'll try to get back to you, but because of limited time, Mr. Rahim, could you please add your opinion to this? Why do we keep seeing this? The provincial court system, the federal is helping, has provided resources, but this is also that jurisdiction.
Well, certainly first what I would say is it's challenging to talk about that issue when we cannot also know the number of individuals who perhaps had a prior record but who are released and don't allegedly reoffend. So those headlines are important, as you say, but it's challenging to draw a conclusion that there is just undue leniency if we don't know the full picture. Now, as for those specific cases, of course, it is impossible to perfectly predict risk. We have decided as a constitutional democracy not to live in a system where as soon as you are charged, even if you have a record, you are put into jail. So there is a balancing that has to occur, but that does not mean we should not act upon the examples you cite. We just need to do so when we have the data to properly assess the problem.
How do you think we would better be able to acquire this data and to track how many people are on bail and to see what we can do to make sure to limit these releases?
I'll tell you precisely how. So there is a center at Statistics Canada that is responsible for collecting different types of information. Information comes from the police to the Uniform Crime Reporting Survey. It comes from corrections through their surveys and databases. The provinces and territories have to sit down with the federal government and figure out how do we transmit that data that is collected so that it can be analyzed and broken down and assessed in the same way. And the fact of the matter is that both levels of government have not taken any public-facing steps since Bill C-75 or Bill C-48 to tell us how they are actually going to collect that information. So that's something that we need leaders in all jurisdictions to step up and do.
What would you suggest? How is it up? Okay.
Before we leave today, first, obviously, I want to thank the witnesses for taking the time to come in and give us their testimony. I apologize to people listening for the communication issues for folks online, but that was quickly resolved. Before people leave, members, we will need, depending on what we decide occurs next Thursday, witness lists for the study, assuming or presuming the absence of the minister. But we will convene. So get your witness lists in by Monday around 4 o'clock if that's acceptable. And we'll have a brief session on Tuesday in camera to decide a couple of these items, including how we proceed with the study of C9. On that, I wish you all a good Friday and a good weekend. Thank you.